Hi, this is Shannon Ella from Both Sides of the Couch. We did an ethics blog about our workshop for general ethics training, and we have a secondary one called Courtroom Ethics. Some of the information, the PowerPoints and those kind of things are similar, but there are things that are more specific to going to court and working with attorneys and judges and working with defects and mandated cases. So I wanted to be able to show you the difference between the two in case that you wanted to see a different view toward an ethics training. If you're a counselor and you're wanting to become comfortable going to court and knowing how to be credentialed as an expert witness and have your testimony carry the weight that you would like for it to so you can advocate for your clients, this is an excellent training for you to do and get this specialized information. If you're a client and you're looking for a counseling practice that then is very familiar with courts and attorneys and judges and not fearful or have anxiety about going to court and advocating for you, this is also something that you would think about coming here as a client, because we do this routinely and have a great deal of experience going to court and successfully advocating for our clients. Another thing that's in this particular training are the guidelines for responding to subpoenas. One thing I think you need to remember about that, a subpoena is requesting your appearance, and it's mandating your appearance to a certain legal hearing. It is not mandating that you speak to an attorney and give them information, privileged information about your client. And it doesn't, if you're a client and you're bringing a subpoena to a particular practice, it doesn't mean that they have to testify to the things that you're hoping they'll testify. It merely means that they have to show up in court. This next handout that's different for this particular training is how to testify in court. The courtroom dress and demeanor. What direct examination is. That's when the attorney that's friendly to you is asking you questions. Cross-examination is the opposing attorney getting to come back and ask questions to make their case. And rebuttal is when your attorney steps back up and gives you an opportunity to respond for the information that the other attorney was questioning. It gives you different information about attorneys' approaches, leading questions, badgering, lulling the witness, starting off very slowly with something general and then coming into a question that you're not expecting, staring at the witness with intimidation tactics, how to stay calm in court, how to have your information together in a written format, knowing that if you take any kind of information like a client's chart into court, it can be taken away from you and you may not get it back. And then that client's entire privileged information has been compromised. Also, how to be prepared. We have a clinical summary that you can gain in this particular training that will show you how to gather all your information into a solid written document that you can then testify from with confidence. How to know the cases and the facts, how to have the difference between factual testimony, hearsay, opinionated testimony, and understanding how to craft your testimony so that you can be heard and advocate for your client in the best possible way. The last thing we have in this training that's different than the main ethics training that we have are courtroom scenarios, things that you might encounter when you're in court testifying for your clients. Either way, whether you're a client or a clinician looking to either find a counseling practice that's very skilled at going to court, or you want to become better at that yourself, check this training out. Give us a call at Shannon Eller, 770-468-7424. Brighter tomorrows, and here we are signing off again from Both Sides of the Couch. We'll see you again next week.